that is the date when the intergovernmental agreement was signed between all the governments. But the population is not party to these agreements. We are not participants to this agreement. So our case remains that as long as we are not party to this agreement, we can only file at the time that we get to know about it, and this is when this was published. Unfortunately, although we tried to bring this out in our arguments, court hasn't pronounced itself very clearly on this issue. They still went back and alluded to the date that the agreement was signed, but not the date when actually the general public got to know about this agreement. So this is what put us out of time. However, there are still a lot of redress mechanisms. I'm going to quote the African Charter on Human and People's Rights, specifically Article 21, Sub-Article 5. And it says that state parties to the present charter, to which all East African Community states belong, shall undertake to eliminate all forms of foreign economic exploitation, particularly that practiced by international monopolies, so as to enable their peoples to fully benefit from the advantages derived from their national resources. So I think as long as we continue to hinge on the legal framework that we have, we still have a lot of redress mechanisms that we can explore.
At a time when scientists are telling us that we must do everything to promote biodiversity conservation, we felt that the Eacop project developers were being irresponsible and were violating international conventions such as the post-2020 Convention on Biological Diversity.
Call that preliminary objection. So we felt the dismissal of our case was quite unfair on that particular ground. Unfortunately, the judges were persuaded with the respondents, and they ruled on this issue that the preliminary objection was proper, and thus on this particular issue they found out that we lost on the very first ground. The other ground, which is the second ground, was the issue of time. So it was quite central to this particular case.
So we are calling the efforts of our brothers and sisters globally, not only in Uganda and Tanzania. The challenges are there. And just to assure the project affected persons in Uganda and Tanzania, we are still together. It is a very disappointment today about the ruling of the appeal case, but there are other doors and there are other means to still constraining this pipeline. I'm quite sure they will not manage to construct it and the crude will not flow.
Kazi-Njema, online, live from Hoima City.